Namaskar. I'm Assistant Professor Kritika Dev from LJ School of Law. Today we'll be dealing with another topic under Indian Evidence Act and of course the set of sections. So whenever we talk about evidence, we talk about set of sections because they are there under one heading, right? Most of the sections. So this is one of them. We'll be reading set of sections which talks about oral evidence. You must have heard about oral evidence or documentary evidence. So before moving on to the documentary evidence in the next session, we will need to understand what oral evidence is. So let's start with it. So now here, let's see the introduction part. Now what the introduction part says, what is an oral evidence? Now when it comes to actually getting the terms, we need to have its reference somewhere. So when it comes to this very fact, it is mentioned under section 3 of the Indian Evidence Act itself. So now what section 3 of the Evidence Act says, that it is any evidence which the court requires or permits to be given by the witness relating to any fact and issue. So by this you could have understood two things, whether the court permits to give through a witness or the court requires by itself that very oral evidence, the court requires this to be made. Right, when it comes to the powers of the court, courts have wide powers. And on any point if the court is not satisfied, of course that the court can ask for other oral evidences of the same fact and issue. Then the two things, either the court requires or permits to be given by a witness, but the both thing should be related to fact and issue. Nothing other than fact and issue, it should be related to the fact and issue or the relevant fact. Right, and that is mentioned under section 3 of the Indian Evidence Act. Now, section 59 of the Evidence Act says, proof of facts by oral evidence. Now let's read the whole thing in the definition. All facts except the contents of the documents or electronic records may be proved by oral evidence. So here we were thinking of getting more of the definition. Here we have got the exception. Now what are the exception? The exceptions are two, right? Or you can say it is just one, but one is a document thing and other is the electronic record. So all facts, right, may be proved by the oral evidence except the contents of the document. It means if there are contents, if there is a document, the contents of the same cannot be proved by oral evidence. This is what this section is trying to say. Or the electronic records or the contents of the electronic records. So document or the electronic events, electronic records, in these two categories, the contents, whatever is written in the document, it cannot be proved by an oral evidence. For that, you need to show the document. Right? So this is the thing which is being given under section 59 of the Indian Evidence Act. Now let's move on to the next section through which we will understand what the oral evidence is. Now section 60 says what oral evidence is. Oral evidence must, in all cases, whatever, it should be direct. Now, when it comes to oral evidence, the section requires it to be direct in nature. It should not be indirect in nature. Now, what do we mean by direct and what do we mean by indirect? That we will see in this session only. So, let's read the direct ones. What do we mean by direct evidence? If it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. Now here let me quote one example for this. First say, if something could be seen, first say A stabbing B, that could be seen, right? It could be seen by people. So now when this fact could be seen, then the person it must be the evidence of a witness who says he saw it. So when it comes to the oral evidence of that very thing, that, oh, A stabbed B. Now somebody wants to give an oral evidence regarding it. So it should come from a person who says who has seen it, who has seen A stabbing B. A is trying to stab B, and that is the fact in a show, right? And now this could be seen. A is stabbing B, this could be seen. Now, for this, oral evidence could be only given by the person who says that he has seen A stabbing B. You're getting my point? The oral evidence should come from a person who says that who has seen it. The next one is if it refers to a fact which could be heard, it must be the evidence of a witness who says he has heard it. So now let's take an example. If somebody has heard that the screaming or anything, right? There is a question. There was a scream during, you know, during that fact in issue. Now, the evidence should come, the oral evidence. Here, the oral evidence means the somebody who's coming as a witness here. Now, the oral evidence should come from a person who had actually heard that screaming. He's coming with an oral evidence, right? That yes, sir, I have in front of the honorable court by stating, yes, sir, I've heard that very scream. So now this person should have heard that very scream, not some other person. Not by saying, I heard that person stating in front of me that he had heard that very scream. No, he himself should have heard that very scream. Is that all right? Okay. When it refers to a fact which could be perceived by any other sense or any other manner, it may be evidence of a witness who says he perceived it by that sense or in that manner. First, say if it comes to people, uh, it is since 10 days that that very place is stinking very badly. It is, we can smell something very bad there in that very house. So when it comes to that stinking which could be perceived by your nose, it is one of the senses, right? So it should come from a person who had perceived it through that very sense. So the person who has actually smelled it and who is actually feeling that foul smell coming from that house or from that area should come to the court by stating that I have actually, I got that foul smell and it was stinking very badly, right? It could be a dead body, it could be anything, it could be anything, but he himself perceived it by a sense, that is through his nose. The next one is if it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion. You remember the expert opinion? So here, if somebody holds that very opinion in a case, then of course that expert should only be called. So here we could relate, right? The opinion. So the person who's holding that very opinion should be called before the honorable court in order to give that very opinion, in order to give that very oral evidence, right? The person who's holding that very opinion, correct? So this is about section 60. Now, as I said, direct and indirect. So when it comes to section 59, every evidence is direct in nature, right? If it could be seen by the person who has seen it, if it could be heard by the person who has heard it, if it could be perceived by any other sense, then the person who has actually perceived it by his senses. Now it comes to, let's come to the indirect one. In those cases, I had given you one example, right? If that person says that B told me that he had heard that very scream coming from that very door or that very house or that very place, right? So here the heading is hearsay evidence is no evidence. Something that you have heard from other person, that other person might be the main evidence, might be the main witness, but if you heard that person stating that in front of you, then that is not an evidence. That will be termed as hearsay. You have heard somebody stating that to you. You have not seen it by yourself. First, say if A has actually seen a murder. Now A comes to me, I'm just a normal person, comes to me and says, I've seen that murder. I go to the court as a witness. That A stated to me that he had seen Y murdering Z, right? Y is murdering Z, and that had been stated by A to me. Now, was I the person who witnessed the murder? No, I was not the person. I just got an hearsay evidence. I just heard A saying it to me. I do not know whether Y killed Z or Z killed Y or any other person killed Z or Y. So the evidence that I've got here is an hearsay evidence. And the one I will be giving will be known as the hearsay evidence because I've heard that person saying, I'm not sure about it. I have no clue about it because I have not seen it myself. So here when it comes to oral evidence, of course, I will be giving it through the oral medium. I would be saying the same. But it would be termed as an hearsay evidence because it is not direct in nature. I have not seen it. I have not heard it. I have not perceived it by my senses. I have heard somebody else who might have seen it. I do not know. And I am communicating the same what he has communicated to me. So it will be termed as an hearsay evidence, right? And when it comes to the oral evidence, hearsay evidence is no evidence, right? So before this section, we were seeing the direct evidence, the direct oral evidence, which are accepted as the oral evidence, and we had even seen the exceptions that everything can be proved by oral evidence except the contents of the document, the document, the hard copy, or the electronic record. Everything can be proved other than that through the oral medium, right? And hearsay is no evidence because it is an indirect one. And nobody can rely upon the hearsay evidence, right? Because what A had told me, I am communicating the same to the court. There is no question of cross examining or anything like that in this case because I will simply say A had stated that to me, rest I don't know. A had stated that to me, rest I don't know. So it will become very difficult for the court to rely upon that, right? So with this, I would like to rest my lecture. I hope you must have understood everything very clearly and keep the bare acts, read it once again, revise it once again till our next lecture. Till then, kindly take care of yourself and keep studying. Thank you.